My name is Melissa Kane. I'm the host of Get Out the Bet, an attorney and a political analyst. It is my pleasure to introduce Michael Gerhardt. He is a professor, a Burton Craig Distinguished Professor of Jurisprudence at the University of North Carolina Law School. Now, Professor Gerhardt is one of only 2 legal scholars to testify at 4 different presidential impeachment proceedings. He has testified before Congress more than 20 times. He has served as special counsel to the Senate Judiciary Committee for 8 of the 9 Supreme Court justices and was most recently one of the 4 constitutional scholars called by the House Judiciary Committee during President Trump's impeachment proceedings. So when it comes to impeachment, it just doesn't get much better than Professor Gerhardt. And tonight we're going to be discussing Professor Gerhardt's new book, The Law of Presidential Impeachment, a guide for an engaged citizen. Professor Gerhardt, thank you so much for joining us.
Well, thank you very much.
Alrighty, let's begin with some news of the day. We're going to get more into the book, but I want to talk about some current events, including today, the House Rules Committee. I don't know if they've already voted, but as of right now, I haven't seen the actual vote. I think we kind of know how that's going to go, but to begin and to initiate impeachment proceedings against the Secretary of the Department of Homeland Security, and Alejandro Mayorkas. Have you been following this latest effort at impeachment, and tell us your thoughts?
Yes, I've been following it pretty closely. So the effort to impeach Secretary Mayorkas has really just begun in earnest this year. It's been pushed through really fast. It's been pushed through without any evidence. And it's been pushed through largely on the basis of policy differences between the Secretary and Republican leaders in Congress. So that's a way of saying that there's not a legitimate basis for it. I think what we're seeing with the impeachment of Secretary Mayorkas is an effort to trivialize impeachment, to turn it into a partisan weapon, to sort of use against President Biden and his immigration policies. Today, with the Rules Committee, we expect a party line vote. There will likely be a party line vote in the House, but I think this comes down to moderate Republicans in the House. They have to decide whether or not they want to be a party to what I think is pretty clearly an abuse of the impeachment power.
Well, so the grounds that they're claiming for impeachment are a refusal to comply with the law and a breach of public trust. These are sort of the 2 main counts. And they basically turn on these, I think, 7 instances where the law requires the DHS to detain people who are unlawfully or don't have a legitimate reason to be in the U.S., but they are not doing that. They are releasing folks or giving them ankle monitors, or they're doing things that are not detention as required by law. And that's the breach of public trust, and that is the failure to comply with the law. Now, is the notion that even if that was true, even though you might disagree that it is, even if that was true, it would not constitute grounds for impeachment?
I don't think it constitutes grounds for impeachment for a couple of reasons. So let's assume that all of that is true. It's been true of other presidents as well. And part of the reason for that is because under the laws, there is only so much the chief executive can do with regard to sort of keeping people in detention if they're caught at the border. Because Congress hasn't moved on this, there's underfunding for their detention. That's hardly President Biden's fault. And so President Biden actually is doing almost exactly what President Trump had done under the same kind of circumstances. But it's been a little more difficult for President Biden because he has a Congress, particularly the House, that doesn't want to fund any more support for security at the border. So there's also the wide discretion that a president has to determine how to enforce a law. And this is a particularly important thing if the president doesn't have full resources, to be able to ensure rigorous and full compliance with the law. So a president has to make choices about how best to enforce the law with the meager resources he might have. That's not unique to President Biden. Every president has to do that. And so what we're really seeing are complaints against President Biden that he has not been able to do more given the meager resources that he has, but he is trying to enforce the law, and he is actually following precedents set by earlier presidents in doing so. So it's hard to argue that that's an illegitimate ground for President Biden to operate. And in addition, Secretary Mayorkas' job is to help President Biden implement his priorities and particularly enforce immigration law. And by all accounts, that's what he's done. He just hasn't enforced it in a way that complies with or is consistent with what the Republicans want. And that just takes us back to what is this basic policy difference. They want to see all sorts of things which either are not really possible under the law, or they want to return to how things were under President Trump. But what they're ignoring is that President Biden is the president, and he has discretion on how to enforce the law, and that's exactly what he's doing.
And in your estimation, this doesn't rise to the level of high crimes and misdemeanors, treason, or bribery as required?
Right. It's a disagreement, ultimately, over the fact that President Biden is not President Trump, and that President Biden is enforcing immigration law in good faith. And that's not a legitimate basis for impeachment. That is, however, a perfectly appropriate subject for an election to decide. And therefore, impeachment in this instance is used just to sort of make the Republicans' point that Biden is not Trump when it comes to immigration. That is not a legitimate basis for impeachment.
And we've seen, as you write about in your book, of course, impeachment. Let's assume the House votes to impeach Secretary Mayorkas. What we've seen over and over again is that the Senate fails to remove, even though there's the impeachment in the House. And so it does turn into this statement, right, more than a true effort. And as you write in your book, now you didn't write about Mayorkas in your book because this is very recent, but that William Belknap was the prior cabinet secretary to be impeached, and that was back in 1876. So it is unusual to go after cabinet members in this way. It
is very unusual to go after cabinet members in this way, and there's a good reason for that. Cabinet members serve at the pleasure of the president. Their job basically is to do what the president asks them to do. And if you remove a cabinet member, you're just going to get another cabinet member who does exactly the same thing. Therefore, it makes very little sense to go after the cabinet member. If what your problem is with is the basic policy that the president is trying to pursue, that is what is really at stake in these proceedings against Secretary Mayorkas. It's a policy matter, and therefore we should leave it to elections. Imagine if the secretary gets impeached. What would the trial in the Senate look like? The trial in the Senate would be the Republicans would try to put on trial President Biden's immigration policy. In other words, it would sound a lot like and look a lot like a campaign. And that's exactly what a trial should not be. Well, speaking of President Biden, I mean, there also is an effort to impeach President Biden as well. It's, I believe it's in committee sort of status right now. Of course, it's not in sort of full-blown, full House voting just yet. But you've also weighed in on those proceedings as well. Can you talk a little bit about your thoughts? Yes. So the Senate, the House has authorized a few different committees to hold impeachment inquiries against President Biden. And I testified in the one hearing that had been held at the end of September by the House Oversight Committee. What I testified then is what I still believe now, and that is that there was no evidence submitted on that occasion that President Biden had committed any impeachable offense. The Republicans' own expert witness said at that hearing there was no evidence that President Biden had committed any impeachable offense. There are senators, Republican senators, who have said they have not yet seen any evidence that President Biden has committed any impeachable offense. What the hearings have been in the House on has been Hunter Biden. And it may be important to remember that Hunter Biden is not the president of the United States. Hunter Biden is the son of the president of the United States, and he has legal troubles. But there's no evidence to suggest that the president, Joe Biden, has ever been complicit in any of those legal troubles. And I think one reason why we're not seeing more movement on the effort to impeach President Biden is because, again, I think the moderate Republicans are realizing that without any evidence, it's really going to be a joke for them to try and do anything against President Biden through the impeachment process.
Well, and there's a value potentially to continuing to talk about it as opposed to bring it to a vote or go through the process, which eventually will end, instead of just continuing to investigate.
Yeah, I agree with that. And I think one obvious reason why there is all this talk about either impeaching the president or his Secretary of Homeland Security is because the cameras are rolling. And members of Congress who are trying to make cases against the secretary or against the president are getting free airtime. But they're using that free airtime, again, to go after President Biden on the basis of his actions and policies as president of the United States. That is not an appropriate use of impeachment. Donald Trump has asked the House to impeach President Biden because, as Trump said, they did it to me. Well, this is not second grade. This is,
I don't know. Have you been to D.C.?
Not recently. But you're right. But that hardly inspires confidence in what is happening there. And instead, I think what we're seeing is there's an effort to almost dumb down impeachment to, again, just turn it into a kind of joke, which I think could be useful for the Republicans if Donald Trump returns to the White House.
It's such a great point. I mean, I feel a little old saying things like, impeachment used to be a big deal. Like I wrote him back in my day. This is something.
Back in my day.
We watched this on C-SPAN. This is important. That's, and of course, as it becomes more and more, sort of used, more and more talked about, people need to understand better and better how this is supposed to work. And so let us get to finally the book and why you wrote the Guide for the Engaged Citizen. Well,
I appreciate that. So I have done in the past a lot of work on impeachment. I first got interested in impeachment when I was growing up in Mobile, Alabama. I was Jewish in the Deep South in the 1960s and 1970s. And in that circumstance, you would not have known the Supreme Court had ruled in Brown versus Board of Education that state mandated segregation of the races was unconstitutional because our schools were still segregated. You would not have known that the Supreme Court had struck down school prayer because there was still school prayer in public schools. So growing up, I didn't have a great deal of confidence in the implementation of Supreme Court decisions. At the same time, I grew up in the shadow of Watergate. When I think by almost any account or any measure, the Constitution worked as it should have in ultimately forcing Richard Nixon to resign, and that was through the impeachment power. So because of that circumstance, I got really interested in examining the extent to which the Constitution constrains in the absence of judicial review, when courts are not around to sort of second guess. Fast forward a number of years, and because I've been involved with the impeachment process as a witness and a consultant and write a lot about it, I happened to be in Washington on January 5th, meeting with members of Congress on some obstruction of the final certification of the 2020 election. At the end of the day, I drove back to Chapel Hill, and that's one of my favorite moments because I get to see Washington in my rearview mirror. Well, I made a mistake the next day of turning on the television. And then I was back in Washington on January 7th. And I met with Senator Leahy on the Senate floor, and he and several senators then began to show me all the damage that had been done on the Senate floor. The broken desks, the defaced art, the defaced statues, broken windows. And I asked myself two questions. One was, how did we get there? And how do we get out of it? Well, I think how we got there was we live in an era of disinformation and dysfunctional politics. And when you mix those together, I think you get, unfortunately, violence like that. And my thought about, well, how do we get out of it was, well, maybe there's one more book in me. Maybe it might be helpful to try and write a book that just simply cuts through the disinformation and just says, oh, here's what is settled. Here's what we know about the law of presidential impeachment. So it's not really any longer up for debate. And hopefully this could be a useful book to have when the tidal waves of disinformation begin, as they've already started in the House, as we just talked about with Secretary Mayorkas and President Biden, we need to cut through that all that disinformation to get at what is the real heart of impeachment. And my hope is the book sets that out.
Well, it does a great job. It's one of the clearest books by a law professor you're ever going to find. I'll tell you that much.
Thank you.
Now, one of the things that I think is going to be really useful for folks as we get into impeachment proceedings at various points is, and I don't know if it's settled just yet, but I know there was a lot of debate around the Trump's first impeachment around what is impeachment. Is it the House vote, or is it only after the Senate convicts? And if you look at the records of the Constitution, it's pretty clear there's a kind of two separate things. But I want to make sure people, when we talk about impeachment, know exactly what that, what we're talking about, because sometimes it can mean removal, and sometimes it just means the vote in the House. So can you get some clarity around how the process?
Yeah, it's an important matter. So impeachment generally has two different meanings. One is impeachment is what the House does. So the House is given in the Constitution the sole power to impeach. And that means the House may impeach a president for treason, bribery, or other high crimes and misdemeanors. But impeachment also has a more colloquial meaning, which is just a reference to the entire process by which somebody goes through impeachment in the House and a trial in the Senate, which reaches some conclusion, perhaps a conviction and removal. So we just need to look at the context to figure out what meaning of impeachment we're talking about.
Right. So when we say President Trump was impeached, we don't mean that he was removed, but you would still say he was, in fact,
right.
impeached.
So let's get that straight. I mean, the facts are clear. President Trump was impeached not once, but twice. President Clinton was impeached. Richard Nixon came close to being impeached, but he was not. On the verge, right after the House Judiciary Committee approved 3 articles of impeachment against Richard Nixon, Nixon ultimately resigned. And that was based in part on evidence he ended up having to share with the House, because the U.S. Supreme Court unanimously ordered him to share that evidence with the special prosecutor, and then the House wanted that information. We're talking about tapes, tape-recorded conversations in the White House in which Nixon basically incriminated himself. So when we look more closely at the instances in which the House either impeached a president or came close to impeaching a president, we're not talking about many of them, but it's important to understand what went on with each of them.
I like to think of it as the House is sort of the DA, right? They take in all the evidence, they decide whether or not to bring a case, and then the Senate is more what we think of as the actual trial of guilt or innocence,
yes.
And that's it meets out that removal punishment. But it's easy to get confused and have people say, "Oh, well, I wasn't
yes.
impeached." Well,
so in the House, it's an impeachment. In the Senate, it's supposed to be a trial. The House sometimes has arguments about, are we more like a DA or grand jury? But one thing that seems to come through clearly is the House is not the final word. The House has its judgment on whether there's an impeachable offense and what evidence there may be, but the Senate is not obliged in any way to accept the House's judgment. They can rethink all of that. They can decide, oh, we don't think there's an impeachable offense, or they can decide we don't think there's any evidence of it.
Well, and the Constitution basically lays out just sort of what are impeachable offenses, and broadly speaking, the House tries the impeachment, the Senate then tries the case and decides on removal. But other than that, they kind of make it up. And in your book, you actually start at the beginning with President Johnson, and who came so close to being impeached, but where we get a lot of our sort of rules around how this whole thing works.
Right. So one of the big questions, of course, about impeachment is what counts as an impeachable offense? And that question becomes front and center with Andrew Johnson. Andrew Johnson was about as unpopular president as we could ever imagine. He takes over after the assassination of Abraham Lincoln. He is a man without a party at that point. He had been a Democrat, but the Democrats didn't like him because he hadn't gone back to the Confederacy. He ran instead as a running mate of Abraham Lincoln and Lincoln's run for re-election. Lincoln, having witnessed Johnson inebriated on Inauguration Day and stumbled through his speech, said to somebody else in the cabinet, "Keep that man away from me." And they never really interacted after that. So Johnson, as president, was not operating from a strong political base. He was also operating in light of real dislike in Congress. And
That's a polite way to put it.
Yeah, Congress was therefore interested in trying to get rid of him pretty much from the beginning. Johnson ultimately helps them by arguably not complying with a law called the Tenure in Office Act, so Johnson suspended his Secretary of War, Edwin Stanton.
One of the great figures in
yes, one of the great figures
in
during the Civil
history,
War.
and hilarious.
Yes, really well done in the movie Lincoln.
Yes.
And so the House looked at that suspension and said, we think it's a violation of this Tenure in Office Act, which Johnson had vetoed and which was enacted over his veto. Then the matter goes to the Senate. And in the Senate, there's a debate. Okay, is really firing somebody or dismissing a Secretary of War or suspending him, like Johnson did, does that rise to the level of an impeachable offense? The Senate acquits Johnson by a single vote, so there's a pretty strong feeling that the Senate did not sign off on the fact that there was really a genuine impeachable offense. And instead, I think the conventional wisdom here is right, that what happened with Andrew Johnson is the impeachment was all over his differences between himself and the Republican leadership over Reconstruction. So policy disagreements were the motivating factor, and his acquittal, I think, is taken as an important sign that policy disagreements are not an appropriate basis for impeachment.
Well, it's also a sign of the incredible dysfunction at the time. I mean, it's almost comforting how atrocious the politics were around this impeachment proceeding. And you talk about it in the book, where you have the Supreme Court Justice Chase, who has his own aspirations for the presidency, and he's really trying to manipulate the proceedings in the Senate for his own benefit and to denigrate potential opponents. I mean, it was, it almost, we got through that. I sort of look at that and go, well, that was really horrifying. And there's this whole theory, I think, that that the one vote, the single vote that saved Andrew Johnson, was actually the result of a bribe,
right,
and not necessarily a profile in courage.
You're absolutely right. Yeah. So in Profiles in Courage, it was suggested they were courageous votes. Subsequent historiography suggests that the bribes were pretty rampant. And so it may not have been a really principled decision. But I think one thing we also learned from the Johnson impeachment is the impeachment of a president brings out the best in people, but it also brings out the worst in people. I think a second thing we learn is that the president's lawyers in an impeachment proceeding, particularly once it gets to the Senate, they have an incentive to narrow the field of what would be an impeachable offense. So Johnson's lawyers, and they were good lawyers, argued that a president could only be impeached for an indictable crime. That was real convenient for Johnson because he wasn't really accused of having committed an indictable crime. Therefore, it was easy in the Senate for the lawyers to say, look, there's really no legitimate basis. Later, we see presidents change their arguments about what is not an impeachable offense, but it's always changing in a way that ensures that whatever their misconduct is, it's not covered by the Constitution.
Well, and you do argue pretty convincingly that this comes up every time, whether or not it has to actually be a crime in order to be an impeachable offense, and that's really never, wasn't the intent, and that's really not the case, right. Even though we do have to do this dance.
Right.
Every time it comes up.
And we do this dance because I think it's politically driven. However, I do think it's pretty well settled what qualifies as an impeachable offense. So we know from the language of the Constitution, treason and bribery count as impeachable offenses. And then the other language, other high crimes and misdemeanors, troubles a lot of people because it's not everyday language. It's technical language. These are terms of art borrowed from the British, and they refer to what the British understood as political crimes, which were offenses against the Republic. They were abuses of power by leaders that hurt the country. And so that's the metric, so to speak. And then we look at the particular misconduct in any given case, and we ask two questions. What's the context of the misconduct, and how serious is that misconduct? And we figure out from looking at the context and the gravity of the offense whether or not it rises to the level of something like treason and bribery, or is it maybe a mistake, or is it even some kind of misconduct that falls short of a serious abuse of power or seriously hurting the country.
Well, I think just people hear crime, which, high crimes, right, which, sounds like a thing that needs to be a crime. And then misdemeanor, which we understand to be part of the criminal justice system and part of the code. And there was even one of the delegates at the convention said, I don't like the idea that you can be impeached for a misdemeanor. It just doesn't sound, and I'm paraphrasing, obviously, but it doesn't sound like it has the kind of gravity that you need to sort of get there. And I think that confuses people.
It does. It does confuse people, but you have to remember, we all have to remember, that the Constitution was drafted in 1787. It was not drafted with our current understanding of the words crime or misdemeanor. That's one thing. The second thing we have to remember is these terms are modified by the word high. So it's high crimes. Now, why does that phrase appear? That's not something we use today. We don't go around saying, oh, that's a high crime or not a high crime. But that was, the British used the word high to describe an offense against the state. Mm. And so we understand that term from its original context, which was the British. And then we look at misdemeanors that are on the same level of offense. So it's and what we come down to is recognizing that abuses of power are what impeachment should be focused on.
And you do write about that an abuse of power is really kind of the touchstone for an impeachable offense. But I do want to ask you how, when you're a teenager, everything your parents say is an abuse of power. Like it's a matter of where you're sitting and where the other person's sitting. So an abuse of power is fairly elastic as well, depending on, you could say Mayorkas is being impeached for an abuse of power if if that's the lens you're looking through. So what ways do you suggest to sort of dial that in or make that exclude something that the other party doesn't?
Well, I think this is the point at which I think we care about the context in which the misconduct arose and the gravity of the misconduct. So the context will tell us the situation, the circumstances, even the office within which the misconduct took place. The cabinet secretary, for example, doing something. Well, a cabinet secretary who's not breaking the law, but in fact is enforcing the law as the president has seen fit, does not seem to fit that definition of an abuse of power or serious injury to the republic. Then we look at the gravity of the offense. And again, we'd say, well, if it's a secretary of Homeland Security and this person's enforcing the law within a system that everybody recognizes is broken, then that also doesn't seem to rise to the level of an impeachable offense. So as long as we sort of maintain some kind of rigor and a more objective or neutral analysis of what the misconduct is in question, we can arrive at a more principled outcome. So, for example, jaywalking is a crime, and I remember seeing Bill Clinton jaywalk when he was president. Now, context. Okay, yeah, he was trying to get a Big Mac. So we say, maybe not great, maybe not healthy, but the context was just walking out to get lunch. That's not exactly a horrible thing for a president to do.
Was it an abuse of power?
And then we get to the gravity.
to walk
How
in traffic.
serious is jaywalking by the president? And I would say not very serious. It doesn't really hurt the republic. He can be held accountable in all sorts of other ways. And the other thing to keep in mind with impeachment is the focus has to be on misconduct that the law doesn't get at in other ways. So with jaywalking, you can give a ticket. And that's one way to get at it. With the abuse of the pardon power, that's not the thing for which anybody goes to jail or prison, but it's the unique power of the presidency which can be abused. And therefore, I think we have to remember that impeachment isn't there for everything. It's largely designed to get at misconduct that is otherwise very difficult to get at through the law.
But they do have a specific exemption and say, essentially, that once you've been removed, the DAs can go after you. Essentially, that you can be prosecuted, that removal is the only thing we're going to do. That's the sort of extent of our punishment, but they specifically allow criminal.
Yes, in fact, there's language in the Constitution that virtually says that. But I think we also should recognize that there's nothing in the Constitution, I believe, that prevents criminal process from working independently from the impeachment process and vice versa. They do not have to be coordinated. They don't have to be done at the same time. They don't have to be done in a particular sequence. So, for example, in the late 1980s, we had 3 federal judges who were all prosecuted and convicted, and 2 of them are in prison before their impeachments began. And those judges challenged the impeachment, saying, oh, it's either double jeopardy or you should have impeached me first. Now, courts threw out those claims, largely on the ground that criminal process and impeachment process are 2 separate proceedings. The only sanctions in impeachment are removal and disqualification, no criminal sanctions there. In England, anybody can be impeached for anything except for the king, and any sanction could be imposed, including death. The framers narrowed that in the Constitution. They said only certain people, president, vice president, and all civil officers in the United States, and the punishments were limited.
And I think one of the reasons the Supreme Court doesn't hear impeachments, one of many reasons, is that there was a fear that they would eventually have to hear some kind of case that's related to it. Like, what if you then prosecute the president and somehow it ends up at the Supreme Court? At the time, the jurisdictions were, a little less clear. But that if you end up at the Supreme Court, you don't want to have the same people who tried the impeachment try the separate
That's exactly right. And in fact, that's Alexander Hamilton mentions that in the Federalist Papers. And something else we should understand, sort of following along that same lines, is one of those judges I mentioned from the late 1980s, Walter Nixon, had challenged the Senate procedures in his trial. And that case went all the way up to the Supreme Court of the United States. And the Supreme Court unanimously said that a judicial challenge to Senate impeachment procedures or Senate impeachment trial procedures is not something we, the Supreme Court, review. All sorts of different reasons for that. One is finality. So there's an understanding that an impeachment decision is final. Otherwise, you could go months not knowing whether the president really was removed or not.
Yikes.
That's awful. And then the second reason is that judges themselves have only one means for being held accountable for their misconduct: impeachment. So if judges, for example, justices could review their impeachment trials, that would create a kind of perverse situation in which they became the ultimate judges on whether or not they should be removed. And the Supreme Court said, that doesn't make any sense to us. Therefore, the final judgment rests with the Senate.
And you also read about how so after the Johnson situation, where it was just some of the procedures were laid down, but there was also just lots of misconduct, that the next time around that we saw an actual trial in the Senate was Justice Rehnquist, yes. Who took a real different approach.
Yes. So with the Johnson impeachment trial, it was, as you said, presided over by Chief Justice Chase. That's the first time, again, we had a presidential impeachment trial, and therefore the first time we had the Chief Justice preside over an impeachment trial. The Constitution expressly says the Chief Justice presides over a presidential impeachment trial.
Oh, wait, can I stop you right there?
That's right.
Can you just talk a little bit about why it is the Supreme Court Chief Justice?
Sure. I think one reason why the framers chose that setup was because otherwise, the officer who usually presides over proceedings in the Senate is the vice president. And so we would have had the prospect of the vice president presiding over the impeachment trial of the one person standing between him and the presidency.
Guilty. We haven't started yet. Sorry. Okay.
So the framers, let's say, were wise enough to realize, that could be a conflict of interest. They were less moved that the Chief Justice might have a conflict of interest in presiding over a presidential impeachment trial. Salmon Chase, the Chief Justice during the Johnson impeachment trial, put that to the test because he wanted to be president. And therefore, he was trying during the trial to help Johnson. And he was trying to help Johnson because he figured that would create problems on the Democratic side and maybe make it easier for him to get elected president. Not exactly admirable stuff.
And he was going out to dinner with
Yes.
some of the members of the Senate who were going to, of course, vote on this.
Yes.
He's like having dinner parties with them. I mean,
Yes.
it's just...
And he's trying to sort of push them. Chief Justice Rehnquist, to his credit, wrote a book about the Johnson impeachment trial and the Chase impeachment trial in 1992. So come 1998, when Chief Justice Rehnquist is presiding over Clinton's trial, he happened to be one of the few people in the country who really understood the process. And Chief Justice Rehnquist figured, I'm not going to be like Chase. I'm going to do as little as possible. Because he also recognized, as Chase initially did not, that anything the Chief Justice rules in an impeachment trial may be appealed to the Senate, and a majority of the Senate can overrule the Chief Justice. So Chief Justice Rehnquist didn't want to be overruled. And later he said after the trial was over, I did very little and I did it very well. Yeah. And he was absolutely right.
My senior quote. And also someone who worked for Chief Justice Rehnquist is Chief Justice Roberts.
Exactly.
Who has also taken, I mean, that's the one we recognize, I think, as how neutral he tries to be,
Right.
how sort of, procedural and really, stay out of the fray of making, judgment calls.
Right. So Chief Justice Roberts presided over the first Trump impeachment trial. And as you said, he didn't intervene much. And when he did, he tried to do it in very narrow and mild ways. So he was obviously learning from his mentor, William Rehnquist, that perhaps the best approach for Chief Justice is to keep a low profile, not to become the center of attention in the impeachment trial. And John Roberts succeeded. And by the time there was another impeachment trial, Donald Trump was no longer president. And therefore, Roberts decided in that circumstance, he should not preside over the impeachment trial because the president at the time of that impeachment trial was Joe Biden. And in the United States, we don't have two presidents in office at the same time. Given the fact that Trump was no longer in office, Roberts said, this is not for me. It's not appropriate I do this. Then the question fell to Vice President Harris, who had just been inaugurated.
Right.
And she decided, I think sensibly, I don't want to start my tenure as vice president presiding over the impeachment trial of Donald Trump. So she sort of said no. And then that left the decision to the Senate Pro Tem, who was the most senior member of the majority party. That was Patrick Leahy. And Leahy agreed to do it. And I had the honor of serving as special counsel during that trial.
As you point out, of course, and as we know, no one has ever been removed as a result. Like, it always sort of stops in the Senate, whether it be the one vote or by multiple votes. Although there are times when there's some party crossover, right. But it's hard to tell if this is a good or bad thing. And I wanted to get your thoughts on you. So we've got this 2/3 requirement in the Senate, and it is, sort of both the wall that we keep running into, right. But should that be there? Would you think it would be helpful to have a lower threshold for example?
Well, it's a really tough question, but it's a fair question. It's something we think about a lot. The 2/3 threshold for conviction is extremely difficult, if not impossible, to satisfy in the case of a president. It's hard to get at least 2/3 of the Senate to agree on anything, like should we celebrate Arbor Day or something, or recognize the Super Bowl winner. So as a practical matter, you're likely not to be able to get at least 2/3 of the Senate to agree to do the most traumatic thing it could ever do, which is remove the president of the United States. Mm-hmm. That suggests that maybe we need to have lowered the bar, but the framers put it that high to ensure that this power wouldn't be abused. And I think we've been left then with the realization that impeachment is only one mechanism for addressing presidential misconduct. There are a lot of other mechanisms that are also available under the Constitution, and we have to remember that all of them are available at any given time.
Like what?
With any given president. Well, there are criminal proceedings. That's one possibility.
Right.
There's also Section 3 of the 14th Amendment, which may come up.
Right.
And there's also the popular pressure or popular opinion. One mechanism which is probably less effective is reelections, or putting the president to the test of a reelection. And it's not insignificant that the 3 presidents who have faced serious impeachment processes were either reelected, Richard Nixon and Bill Clinton, and therefore that was no longer available as a check against them, or they had lost reelection, Donald Trump, and therefore that wasn't a prospect either at the time of his trial. So we fall back on these other possibilities, criminal proceedings, Section 3 of the 14th Amendment. Those are probably 2 of the biggest.
But if the point is to, instead of, checking their behavior, which apparently it doesn't, then if the point is to get them out of office, right, is removal, then that term limit achieves, something similar, or basically the same thing. If the goal is let's not have this person in power anymore, we do still have that power, right? I mean,
well, if the people are willing to exercise it, that is one possibility. But I would suggest that I think impeachment isn't just about removal or disqualification. Impeachment also, I think, acts as a kind of taint on a president's legacy. It's not something presidents like. And if presidents have been impeached, like Bill Clinton, let's say, or Donald Trump, they do not like it. And it's clear they don't like it. Bill Clinton doesn't like the fact that his obituary is going to open with saying he's the 2nd president to have been impeached. We know Donald Trump doesn't like it. That's why he's asked the House to impeach Joe Biden.
And to remove his impeachment. There is a resolution. Is that a thing?
No.
Okay.
No. There would be no legitimate way to expunge an impeachment. It's already done.
Oh.
It's already happened. And the thing about even that effort today is, let's say in 2024, it would be silly because we have the entire record on video and recorded, and that's never going to be erased. So the fact is, once the president's been impeached, then that president has to learn to live with it. And presidents don't like to live with that taint on their presidency. And it tends to also affect their popularity, and it tends to also affect how they're remembered and their reputation. Presidents care about those things, and those things are really diminished as a result of impeachment.
Well, but if you have Donald Trump, who has been impeached twice and is still the front runner for the GOP nomination, potentially president again, does it still have the same power if you can go through 2 of them and still, be quite popular? Well,
we're all going to be able to sort of watch what the answer may be. The fact is that he can't run from those 2 impeachments. So his choice is to try and say, well, let's either turn impeachment into a joke, or I'm going to suggest an alternative universe of facts in which I didn't engage in any misconduct in 2019 or 2021, and therefore there was no legitimate ground for impeaching me. I think there are voluminous records that say otherwise, and I think that is something that he cannot escape.
Should it be harder in the House? Maybe as hard in the House as it is in the Senate. It should be 2/3 vote. If you had a magic wand to change the Constitution, I'm sure there are other provisions you would like to change too, but this one.
I think it's a great question. I think, yes, raising the bar in the House could be a very effective mechanism for ensuring that there wouldn't be abuse of that power at the very beginning of the process. The framers of the Constitution actually didn't trust the House. So they put all these other institutions in place to check what the House did. So the House did have the power of impeachment, but then the Senate had the power to make the last judgment, to try impeachments. And so one thing to think about is, well, maybe it's too easy for the House to reach that majority. But historically, less than 20, only about 20 people have actually been impeached. It's not a gigantic number. And part of the reason for that is because the House historically, I think, has understood that this is a power we only use as a last resort. We don't use it as a partisan weapon. If our understanding changes.
Has changed.
If it changes, and it could. You could be right. It could be something that has ultimately changed. Then we have to see what the effect of the Senate judgment would be, because we know the Senate isn't going to convict, and how quickly the Senate moves to get rid of it may become an important precedent for the future. Remember, Johnson was acquitted, and we don't impeach presidents anymore, or we haven't since Johnson, on the basis of policy differences. So that's lasted quite a long time because of the Senate decision. And whether or not the Senate decision, whether it be on Mayorkas or Biden, is respected over time will be the real test.
The founders were concerned about the fact that this impeachment happens in the House and the Senate would make the president dependent on the legislature. They thought it would muck up the checks and balances between the two branches. Right. And I think that ultimately they just had to sort of say it has to live somewhere. It can't live in the Supreme Court. So here. Do you think that they were right to be concerned? Has that played out? Do you think that that there's any evidence that that presidents do feel a need to kowtow to the legislature or hold off on vetoing things, the kinds of things the president's supposed to do to keep that branch in check?
I do think there's evidence to suggest impeachment serves as a check in preventing presidents or encouraging presidents not to do certain things. So that's another sort of set of evidence we've got that impeachment may work better than we might imagine. So, for example, Richard Nixon thought for a moment about not complying with the unanimous Supreme Court decision that he comply with a judicial subpoena to turn over some evidence to the special prosecutor. Nixon thought about it. His lawyer said, if you do that, you will absolutely be impeached and removed. And so Nixon didn't do it. So that's one example. Donald Trump thought about firing Robert Mueller. But his chief counsel told him at the time, you do that, you will be absolutely impeached and probably removed. So he didn't do it. So the times when impeachment may work the best are the times we almost never see it happen because it's preventing something from happening. And so that's something encouraging, I think, about the process. But again, to come back to your suggestion, raising the bar even to 60% of the Senate may not necessarily be a bad idea. 60% of the House may not be a bad idea because it means the House has to be able to reach some kind of bipartisan support for the impeachment itself. And that could be a good thing.
Well, it is maybe too easy in the House and maybe too difficult in the Senate. And the founders, Benjamin Franklin, especially, I think a couple of times at the convention talked about how, if you don't have this escape valve, then you end up with assassination. Then you end up, if it is really impossible, if it is so partisan or so difficult or there's no provision for impeachment, you have to have this thing. Or you'll have assassination, and then a different person argued that you would have civil war because you have no other way to get people out of office, sort of with an official means. Are you concerned about that? That if this thing really is if removal is really effectively off the table for all but the most bonkers behavior, will people feel left like they don't really have an alternative to removing somebody from office? Well,
we've been fortunate that we haven't had to face that challenge yet. I think that is partly because we have not just impeachment, but other mechanisms to function almost like vents, things that enable people to kind of vent their frustration over the president and maybe sort of seek some way to sort of ensure the president's accountability for misconduct. So the Constitution isn't, of course, a perfect document. It is, however, our governing document. And I think with impeachment, one of the things that has functioned relatively well over time is the recognition that impeachment has to be taken seriously, and that it's a last resort, that we typically don't use impeachment unless other mechanisms have failed, or unless we recognize that other mechanisms for legal redress are not going to be available. So that takes us back to the example for a president abuses the pardon power. That's a unique presidential authority. I don't have that authority. Citizens don't have that authority, but presidents do. So when the president abuses power, that is by definition unconstitutional. But it doesn't mean there's going to be a legal process for redressing it. The only way we can reach a judgment that condemns it is through impeachment. And so if we stay faithful to that sort of original understanding of what impeachment's for, I think we can ensure it won't be abused, and it might serve as a useful check.
And one of the options that was presented at the convention in 1787 was to have for removal was to remove on the application, on the application of a majority of the legislatures of the states. So if 26 state legislatures demanded it, a president could be removed. It's one of many proposals that you read and go, oh my goodness. Would that be a better way? Or, you know what I mean? Like, should they have thought of a different way? Do you think that this is the way that makes the most sense?
I don't think it would have been a better way.
We'd be on president number 753.
Well, that's one problem with it. But it also then kind of reverses the problem you talked about before. The framers are concerned about the president being too dependent on the Congress. Well, then if you have that other system, the president becomes too dependent on the states. And incidentally, the president is a federal official. So it probably ultimately doesn't make a lot of sense to have a federal official, particularly the highest ranking federal official, dependent on what states want or think. It might not have happened with Lincoln. There weren't 26 states, I think, that were prepared, of course, to get rid of Lincoln, thankfully. But I think we don't necessarily want states to be ultimately the mechanisms that check the president's abuse of power. The other thing I think it's worth considering is not having the states or even Congress as the entities or institutions responsible for impeachment, but to see whether or not we can imagine other institutions that may be more credible. Is there some other entity or institution that's out there that we think could maybe do a better job of trying to hold the president accountable for misconduct? States may here be a useful example because they consider alternative mechanisms for dealing with their governors or their chief justices who run into problems, and they sometimes use bar associations or other special committees.
Or recall.
Well,
California, we recall people.
If you trust the electoral system, yes. But that also then parallels the parliamentary system the framers are trying to get away from. So impeachment's not supposed to be a popularity vote. So recall has its purpose, but its purpose is not, I think, ultimately to deal with misconduct as opposed to popularity.
Well, and the election itself was, supposed to be the recall, right? That's why we have the 4-year,
right.
the 4-year terms. We have a question here from YouTube. What is the U.S. Supreme Court's role in impeachment, and can it override a conviction? I assume that means a conviction in the Senate. Can it override a conviction? The
Supreme Court, by its own decision, has no power over impeachment. So that takes us back to that case with Walter Nixon, the federal district judge who was challenging the trial procedures in his impeachment trial. And the U.S. Supreme Court said, we have no role here. We have no power or authority to review that process. That's for the final judgment of the Senate. And therefore, we have to recognize that the political accountability of senators is one check that could be used if we don't like what the Senate does.
Well, and, for part of the convention, right, for Madison's initial resolutions, it was the Supreme Court's purview to hear impeachment cases, but they actually removed that because the president appoints the justices to the Supreme Court. And so what they didn't want is somebody who who you just appointed judging your impeachment. Right. And so it was moved to the Senate. So that's part of why that's not a thing that the Senate wants to touch. I mean, the Supreme Court wants to touch. Now, one thing you do talk about in the book that I do want to ask you about is this: what happened when the Senate went from back in Andrew Johnson's day, when it was chosen by the state legislatures, to being popularly elected, the 17th Amendment, and how that impacted impeachment trials. Can you talk about the difference in those election schemes?
Yeah, I think that's a really important point. In fact, Justice Antonin Scalia, in his last public appearance, said he thought that the constitutional amendment that made the most difference was that 17th Amendment, which transformed how senators are chosen. As you say, senators were originally picked by their state legislatures. And the idea behind that was, therefore, the people were only indirectly involved. Again, remember, the framers didn't really trust the people because they thought the people would be intemperate, and they thought that people could only be trustworthy if they were educated and informed.
And this is before Twitter.
Yes, this is
when
before
we know
Twitter.
that is true.
That's right. But once senators become popularly elected, then what follows is they may not perform much differently than the House because they'll be subject to political pressure just as House members are. And that may not be a good thing because it means that then the Senate is going to be more partisan than it might otherwise have been. And that circumstance, I think, leads us to perhaps trust impeachment a little bit less because the authorities, the House and the Senate, are subject to popular election, and popular elections are not necessarily the mechanisms for dealing with presidential misconduct.
And especially when there's partisan issues at stake.
Right.
Although, well, I was going to say the prior group of senators got bribed, so I don't.
Well, of course, the other thing.
How far we can go there.
There were changes that the framers didn't anticipate. Obviously, they didn't anticipate the later amendment to change how senators were elected. They also didn't anticipate the rise of political parties. And political parties now have a sway and influence much greater than the framers ever imagined. So when you combine the rise of political parties with the fact that senators are popularly elected, you have developments which make impeachment, I think, less trustworthy, let's say, less effective than it could have otherwise been.
So do you think that impeachments should be, or the impeachment proceedings are being overused by Congresses, both prior to this one and this one? Do you, in terms of impeaching Trump twice, was the second one? I'm not excusing what happened on January 6th by any stretch, but I just mean like there's, you do this to him twice, and now we have two new sets of impeachment proceedings. I mean, is it, in your estimation, getting a little to be a lever that gets pulled a little too quickly?
I think not. I mean, we're not at that point yet. I look at the impeachments of, let's say, Bill Clinton and Donald Trump as largely the result of their own misconduct. Bill Clinton lied under oath. Bill Clinton attempted to obstruct justice. Now, his defense in part was, it was a personal matter, which is a fair defense. He's basically saying, look, I might have committed misconduct, but it wasn't so serious. It wasn't as serious, let's say, as treason or bribery. It wasn't awful, like we'd say treason, if a president, for example, encouraged insurrection. But when we fast forward to Donald Trump, the first impeachment was based not on anything made up by partisans. It was based on his own conduct. He was caught in a phone conversation asking the president of Ukraine to do something false. That is, to just announce an investigation, a criminal investigation into Joe Biden, not because there was actually any support for it, any proof of it, but just because that was going to help Trump. It was going to besmirch Joe Biden and help Donald Trump. That was an abuse of power, and that became the basis for 2019. 2021, even Mitch McConnell said that Donald Trump was responsible for the insurrection that happened on January 6th. So Donald Trump was responsible for that. Nobody forced him to do it. It wasn't a Democratic dream or fiction. It was misconduct by Donald Trump. So as long as impeachment is focused on actual, provable misconduct, it's not being abused. The cases being made against Mayorkas, Secretary Mayorkas, and President Biden are groundless. There is no evidence for either case. That's the problem. Now, if it turns out that those efforts to impeach become popular, then I think we do have trouble.
Well, and
then I'm sorry to interrupt. And then you may be glad that there's this 2/3 threshold in the Senate to prevent a partisan effort to remove a president for basically nothing.
Well, and I think you might also see senators, I mean, just sort of like in the presidential elections, where one of the things I talk about is their ability to appoint Supreme Court justices. And isn't this important? You know, this vote is important, is for senators. I personally haven't seen it yet, but I could imagine senators running on something like this, like I won't impeach or I will impeach, and to, you know, just sort of make those predictions about their own future conduct, and making that a point of why they should be elected, elected to the Senate, and why we need, you know, we got to get that 2/3 so we can get rid of this person.
That is a risk. And I think what we're witnessing with Secretary Mayorkas and even with President Biden is a test. It's a test for all of us. And it's really a test for the Constitution. Does the Constitution matter or doesn't it? And if the answer is no, then we've decided the Constitution isn't going to save us from what follows. So ultimately, what's going to really matter is whether or not the people can rise to the point of making a decision, not based on their own partisan agenda, but can they at least say, no, we'll accept that the Constitution here has limits and constraints, and we should follow it because that's the supreme law of the land.
We don't seem to be going in that direction, though, right? I mean, you've testified in 1998, and then you were part of. I'm sorry, you didn't testify. Is that?
I did.
Oh, you did. I'm sorry. You did testify in 1998 about the law about impeachment, and also again in 2019. So, what differences did you see in being a participant in both proceedings?
Well, it was like night and day. So in 1998, I was a joint witness called by both sides to testify about whether or not Bill Clinton had committed an impeachable offense or whether there was a legitimate basis for impeaching him. The questions I got from people on both sides of the aisle were all substantive questions about impeachment. And I think that's very fair game. There were questions based on my scholarship, which again, I think was very fair game. And I got one hate letter as a result of that. But that was based on substance. It just disagreed with my view of what the substance of the situation was.
It was Jonathan Turley, wasn't it?
He had testified in the same hearing, and we were not in agreement there. Now, we fast forward to Trump in 2019. After I testified, I got hundreds of death threats.
Oh, my God.
And the only questions I got at the hearing were, who did I vote for in the 2016 election, and did I give money to Barack Obama? I didn't receive any substantive question about impeachment law from anybody on the Republican side. And that's how the country had traveled from 1998 to 2019. Politics got increasingly dysfunctional and personal. And I think that is regrettable. And so that experience, I think, showed me that how far the country had, in some respects, devolved. And the question was whether or not they were going to take impeachment as hostage as a result.
Well, then you know better than anyone why engaged citizens need to learn more from an objective source, and not Twitter or Google or wherever people get their law degrees these days, their alleged law degrees these days. And so it's a great book.
Thank you.
It's an easy read from a law professor, I'll tell you that. It's called The Law of Presidential Impeachment, a guide for the engaged citizen. Go out, get it. It's available on Amazon and whatever your local bookseller is. Professor Gerhardt, thanks so much for being here and answering all my questions, and for trying to help get people engaged and have a better understanding of the impeachment process.
I appreciate it very much. I enjoyed our conversation.
Thank you. Okay.